The envelope was still sealed when my brother set his coffee cup down on my father's dining room table like he already owned it. That small gesture, the casual thud of ceramic on wood, no coaster, no hesitation, told me everything I needed to know about how the next 2 hours were going to go. My brother had driven 4 hours from Phoenix that morning. He brought his wife. She was wearing a silk blouse I recognized from a boutique in Scottsdale that charged $400 for anything with a collar. They had not come to grieve. They had come to collect. My father had died 11 days earlier. Pancreatic cancer, stage 4, diagnosed 14 months before he passed. I had been in that house for most of those 14 months. I had driven him to infusion treatments on Tuesday mornings and waited in plastic chairs reading whatever magazine was 6 months out of date on the side table. I had learned how to manage a feeding tube. I had learned what a good pain day looked like versus a bad one, and I had learned to tell the difference before he even spoke. My name is Claire. I am 38 years old. I am a school librarian in Tucson, Arizona. I drive a 7-year-old sedan with a cracked dashboard. I did not stay in that house for 14 months because I expected anything in return. I want to be clear about that before I tell you what happened next. My brother's name is Daniel. He is 44. He runs a landscaping company that does well enough. According to him, though he refinanced his house twice in 4 years and once called me in November asking if I could cover his kids' school tuition for 1 semester, just until a contract came through. I did. He paid me back 7 months later with a Venmo notification and no message attached. His wife is named Renata. She has opinions about everything and shares all of them, and she has always looked at me the way someone looks at a piece of furniture they're deciding whether to keep or donate. The reading was not at a lawyer's office. It was at the house, because my father had specified that in a note he left with his documents. He wanted it done at the kitchen table where we had eaten every Thanksgiving since 1994. His attorney, a quiet man named Mr. Galveston, who had handled my father's affairs for almost 20 years, arrived at 2 in the afternoon with a brown accordion folder and a manner that suggested he had done this enough times to recognize what kind of room he was walking into. He recognized it immediately. Daniel had already pulled out a yellow legal pad. Renata was sitting with her hands folded in her lap, posture perfect, as though she were about to be photographed. I was standing near the window. I had been awake since 4:30 that morning because the house was too quiet in a way it hadn't been before, and I had spent an hour sitting in my father's chair in the living room, not doing anything in particular. When Mr. Galveston came in, I offered him water. He said, "Yes, thank you." Daniel did not look up from his legal pad. Mr. Galveston opened the accordion folder and took out several documents, and he explained in the methodical way that attorneys explain things that he was here to review the terms of my father's last will and testament. Dated. And here he paused and read the date aloud. Dated March 14th, 2 years prior. Daniel's pen moved. I saw him write the date down. Then Mr. Galveston said that there was also a secondary document he had been instructed to present at this meeting, and he set a sealed envelope on the table. White envelope, standard size, sealed with a strip of red wax, and my father's initials pressed into it. I had never seen it before. Daniel's pen stopped moving. Mr. Galveston read the will first. It was what I expected. The house and its contents to be divided equally. Savings account to be divided equally. A small investment account to be divided equally. My father was a fair man. He had worked as a civil engineer for 30 years, and he believed in things being measured correctly and distributed without waste. Nothing in the will surprised me. Daniel wrote everything down. Renata did the math on her phone, and I watched her type and then stop typing and then type again. Then Mr. Galveston reached for the sealed envelope. He said, before he opened it, that this document had been prepared separately, at a different date, and that it had been held in his firm's safe since the day it was signed. He said my father had been very specific about the conditions under which it should be opened, and that those conditions had now been met. Daniel said, "What conditions?" Mr. Galveston said, "Your father specified that this envelope was to be opened at the first family meeting following his death in the presence of both of his children." Daniel said, "Okay, and what is it?" Mr. Galveston broke the wax seal. "What I need you to understand is that I did not know what was in that envelope either." We talked about his childhood in rural New Mexico, about a road trip he took in 1,979 inches, a truck that broke down twice. We talked about my mother, who had died when I was 9, and about whether there is anything after this, and about what a good life actually looks like when you strip away everything you thought it was supposed to look like. We did not talk about the envelope. He never mentioned it. Not once. So when Mr. Galveston began reading, I was listening just as carefully as Daniel was. The document was titled A Declaration of Testamentary Intent with Supplemental Trust Directive. Mr. Galveston read it slowly and without editorializing. What it said in plain terms was this. My father had established a separate revocable living trust 18 months before his death, which had converted to an irrevocable trust at the time of his passing. The trust held the house. Not the house as a divided asset, the whole house. In trust, with one named beneficiary as primary occupant and trustee, me. The trust had been administered through a third-party institution, a firm called Cornerstone Estate Partners. They were not a bank. They were a licensed trust administration company. My father had chosen them specifically because, as the document stated in language he had clearly written himself and asked Mr. Galveston to formalize, he wanted an entity with no personal interest in the outcome, no family loyalty, no emotional stake, and no ability to be pressured, guilted, or convinced by people who had not been present. That last clause, people who had not been present, he had written that himself. Mr. Galveston said so. Daniel's pen had not moved in several minutes. His legal pad was open to a half-filled page, and he was staring at Mr. Galveston with an expression I can only describe as recalibrating. Renata said, "Wait." Mr. Galveston continued reading. The trust stipulated that I could live in the house for as long as I chose. It could not be sold without my consent. It could not be partitioned. It was structured to be legally resistant to challenge on the grounds of undue influence, because the trust had been established 18 months before my father's death, during a period when 2 independent physicians had documented his full cognitive capacity, and because the trust was administered by a third-party institution rather than any family member. My father had thought of everything. He had done it quietly, without telling me, while I was driving him to infusion treatments and reading outdated magazines in plastic chairs. He had sat across from Mr. Galveston in this same kitchen, I would later learn, on a Tuesday afternoon when I thought he was resting. He had brought a thermos of coffee. He had known exactly what he was doing. Daniel pushed back from the table. He said, "This isn't right." He said, "I'm not sure this is even legal." He said, "She was here influencing him for over a year. That's exactly the kind of situation these protections are supposed to prevent." Mr. Galveston waited until Daniel was finished. Then he explained, again, without rising to meet the accusation, that the trust had been established 18 months prior with independent medical documentation of capacity, and that the structure of the administration through a third party was specifically designed to preclude any claim of undue influence. He said if Daniel wished to contest the trust, that was his right, and he could pursue that through the court system, and he would need to retain separate legal counsel to do so. Renata said, "We will." I said nothing. I was looking at the wax seal on the envelope, which was now in 2 pieces on the table, and I was thinking about my father pressing his initials into warm wax on a Tuesday afternoon in this kitchen, and I was trying not to cry, not because I was sad, but because I recognized exactly what he had done and exactly why, and the weight of that recognition was enormous. Daniel and Renata left before 4 o'clock. She carried her Scottsdale boutique silk blouse out the front door without saying goodbye. He paused in the doorway and looked back at me and said, "You know this isn't over." I said, "Okay." He left. 3 weeks later, I received a certified letter from an attorney in Phoenix. Daniel had filed a petition with the probate court to contest the trust on grounds of undue influence and alleged lack of testamentary capacity. The hearing was scheduled for a Thursday morning, 10 weeks out. I hired an attorney named Miss Reyes, who had 20 years of probate experience and an office covered in succulents, and who, when I explained the situation, looked at the trust documents for 12 minutes and then looked up at me and said, "Your father did everything right." I said, "I know." She said, "Do you understand what Cornerstone Estate Partners being named as successor trustee actually means in this context?" I said, "Explain it to me like I don't." She said, "It means your brother is not fighting you. He is fighting a corporation with no feelings, no family history, no pressure points, and attorneys on retainer whose entire job is to protect this document." She paused. She said, "That is a very different fight than the one he thinks he signed up for." The hearing was on a Thursday in November. The courtroom was smaller than I expected, with fluorescent lighting that made everyone look tired. Daniel arrived with his attorney, a younger man in a suit that was slightly too large across the shoulders, and Renata, who sat in the gallery behind him. They had also brought Daniel's older son, who was 18 and looked uncomfortable and kept checking his phone. I arrived with Miss Reyes, and a representative from Cornerstone Estate Partners named Mr. Aldrich, who was 50-something and wore a dark suit and carried a leather portfolio and had the quiet, unhurried energy of someone who had done this many times and expected to do it many more. He introduced himself to me in the hallway outside the courtroom, shook my hand, and said, "I reviewed your father's file this morning. He was very thorough." I said, "Yes, he was." Mr. Aldrich said, "He left instructions for us, beyond the legal documents. He said, I hope this never needs to happen, but if it does, take care of her." I had to look away at the wall for a moment. The proceedings started at 9. Daniel's attorney opened by arguing that the trust represented a deviation from my father's previously expressed intentions, that the circumstances of its creation, a dying man, alone with his caregiver daughter, meeting privately with an attorney, raised serious questions about whether he had acted freely, and that the speed of its establishment relative to the cancer diagnosis suggested it had been executed under duress or suggestion. The judge, a woman named the Honorable Patricia Morrow, listened without interrupting. She had reading glasses pushed up on her head. When Daniel's attorney finished, she made a note and then turned to Miss Reyes. Miss Reyes stood and presented the documentation in a sequence that I would later describe to my friend as watching someone methodically remove every card from a house of cards, one at a time. The 2 independent physician capacity assessments, dated within 2 weeks of the trust's creation. The timeline showing the trust had been established 18 months before my father's death, well before his condition became critical. The records from Mr. Galveston's office showing my father had initiated the appointment himself, arrived alone, and had been seen without me present. The Cornerstone Estate Partners engagement letter, which my father had signed and which laid out, in his own handwritten addendum, his reasons. Miss Reyes asked Mr. Aldrich to read the addendum aloud. He opened the portfolio. He read. My father had written, "I am making this decision with full awareness of my circumstances. I am not being asked to make it. I am making it because I know my family, and I know what happens when grief enters a room with money already in it. I want the person who is here to be protected by something that cannot be moved by guilt, by pressure, by the passage of time, or by people who mistake loudness for justice. I want a structure, not a sentiment." The courtroom was quiet. Judge Morrow looked at Daniel's attorney. She asked him if he had any documentation to counter the physician assessments. He said no. She asked if he had any documentation suggesting my father had expressed a different intention after the trust was established. He said no. She asked if he had any evidence of communication between me and my father regarding the trust prior to the day of the hearing, meaning evidence that I had known it existed and had influenced its creation. He said no. She said, "Then what you are presenting to me is a theory." He started to respond. She raised one hand. She said, "I want to be precise. A theory that a man who was assessed by 2 independent physicians as fully cognitively capable, who initiated a meeting with his attorney without his daughter present, who established a trust 18 months before his death, who engaged a third-party corporate trustee with a written personal statement, explaining his reasoning that this man somehow did not mean what he documented, is not a theory I can act on." She paused. She looked at the papers in front of her. She said, "What I have in front of me is one of the most clearly constructed estate plans I have seen in this court in several years." Daniel's attorney said he understood, but that the emotional dynamics of a caregiving situation. Judge Morrow said, "Counselor, the law does not penalize people for being present." She set down her papers. She said, "Petition is denied." I did not look at Daniel. I looked at my hands on the table. Miss Reyes put her pen down and folded her hands and said nothing, which I had already learned was her way of saying, "This is what we expected." Mr. Aldrich closed his portfolio. The whole thing was over by 10:40. In the hallway afterward, Daniel came out ahead of his attorney and walked toward me. I thought for a moment he was going to say something angry, the way he had in the doorway of the house, the "we're not done" version of himself. But he stopped about 6 feet away from me, and he looked at me for a long time, and then he said, "Did you know about the envelope?" I said, "No." He looked at the floor. He said, "He never told me he was sick. Not until it was almost over. I didn't know how bad it was." I said, "I know." He said, "I should have been there." I said, "Yes, you should have." He didn't say anything else. He walked to the elevator. Renata was already in it, holding the door with one hand, not looking at me. The doors closed. Miss Reyes came to stand beside me. She asked if I was okay. I said, "I think so." I said, "I don't feel the way I thought I would." She asked how I thought I would feel. I said, like I won something. I said, I just feel like it's over and I'm tired. She said, that's normal. She said, the people who fight hardest in these situations are usually the ones who already lost something a long time ago and didn't realize it. I thought about that for a long time on the drive home. The house was quiet when I got back. It is always quiet now in a different way than it used to be quiet when my father was asleep in the back room, which was a quiet that had breathing underneath it. This is a different quiet. I am still learning it. I sat at the kitchen table where Mr. Galveston had opened the envelope, and I looked at the wax pieces that were still there on the wood because I hadn't had the heart to move them. I thought about my father on a Tuesday afternoon, sitting in this same chair, pressing his initials into warm wax, thinking about me without telling me he was thinking about me. He had always done things that way, quietly, without announcement. He had put me through 2 years of community college without ever making it feel like sacrifice. He had shown up to my classroom twice a year, every year I taught before I moved to the library, sitting in the back row of parent observation days, taking notes in a small notebook, telling me afterward, specifically and thoughtfully, what he had noticed. He was a man who believed that paying attention to someone was the highest form of love, and he had paid attention to everything. He paid attention to Daniel, too. I believe that. I believe he knew exactly what Daniel was, and what he was capable of, and what he was not capable of. And I believe he loved him anyway. And I believe the trust was not a punishment, but a boundary, the kind of thing you build not out of cruelty, but out of clear-eyed knowledge of what will happen if you don't. A structure, not a sentiment. That was what he had written. That was my father entirely. Cornerstone sent me the formal trust administration documents 2 weeks later. The house is mine. Not in the simple way that a thing is yours when someone hands it to you in the structural, documented, protected way that my father had designed with the same precision he had brought to every bridge and drainage system and load-bearing calculation of his 30-year career. He had engineered it. He had done the math. He had made sure it would hold. I rearranged the living room last weekend. I moved the big chair to the window where it can catch the afternoon light. I bought a small plant, a peace lily, because I read they are difficult to kill and I needed something in this house that was still growing. Daniel has not called. I don't know if he will. I leave that door open, not wide, but open, the way my father would have. Because my father believed that people were capable of becoming slightly better than they currently were, given enough time and enough quiet. And I am trying, in the ways that matter, to be his daughter. Some days that is easier than others. But the households, my father made sure of that. And so, in the end, do I